Could you clarify something for me on active production immunity? Does active production immunity go beyond this scenario that I'm going to state? You ask for a computer from a witness. You give that witness act of production immunity that, in my interpretation, is that the agent who has that now in his or her hands, the witness is immune from the agent getting on the stand and saying, that person, this is that person's computer because they gave it to me. Does it go beyond that? Or was there additional immunity for Ms. Mills stating that anything on that computer cannot be used against her?
As I recall it, Congressman, the active production immunity for Ms. Mills was, you give us this computer, we will not use, we the Justice Department, anything we find on the computer directly against you in connection with investigation or prosecution for mishandling of classified information. I think that's how they defined it.
But that goes beyond act of production. Doesn't act of production simply state that I'm the agent, I can't get on the stand and say that belongs to that individual because they simply gave it to me? It sounds like more additional immunity was given that says, and what is on this we cannot hold against you.
Well, I think of it as I still think of it as an active production immunity. That, from my experience, that's what I would characterize that agreement. I guess you're right, there could be a more limited form of active production immunity, which simply says your fact of giving us this object will not be used against you directly. I'd have to think through whether it can be parsed that way, but I think I take your point.
So that's why I'm saying additional immunity was given, and I don't think it was warranted at that point. Let me ask you, we both impaneled many grand juries, investigative grand juries. Why not impanel an investigative grand jury whereby you have reasonable suspicion that a crime may have been committed, and then you have the ability to get warrants, subpoenas, get this information, subpoena witnesses before the grand jury under oath, and if they take the fifth, if it's not the target, if they take the fifth, they simply and say, I'm not going to talk to you, you can give them, whether it's use immunity, the AG can give them that, and you had that authority, and then transactional has to come from the judge. And if they refuse to testify then you can say, fine, we're going to take you before a judge, hold you in contempt, and then you're going to sit in jail until you answer our questions. Wouldn't that have been much simpler and more effective than the way this has gone about? I know that I've done it many, many times, and sometimes we find a situation where there isn't enough evidence, and most of the time we find there is enough evidence.
Yeah, no, it's a reasonable question. And I don't want to talk about grand jury in connection with this case.
That's why I posed it the way I did.
From our training, we know we're never supposed to talk about grand jury publicly, but I can answer more generally than that. If anytime you're talking about the prospect of subpoenaing a computer from a lawyer that involves the lawyer's practice of law, you know you're getting into a big Megillah.
Okay, please let me interrupt you.
Sure.
I understand that clearly. Why did you not decide to go to an investigative grand jury? It would have been cleaner, it would have been much simpler, and you would have had more authority to make these witnesses testify. Not the target, but the witness testify. That seems the way to go, Director. We've done it thousands of times. This just was too convoluted.
Yeah, again, I need to steer clear of talking about grand jury use in a particular matter. In general, in my experience, you can often do things faster with informal agreements, especially when you're interacting with lawyers. In this particular investigation, the investigative team really wanted to get access to the laptops that were used to sort these emails. Okay, those are lawyers' laptops. That is a very complicated thing. I think they were able to navigate it pretty well to get us access.
The media says that Ms. Clinton repeated, the media says, 41 times that I do not recall or do not remember or variations of that. Is that a fact? Or?
I don't know. I'm not counted. I've read the 302, obviously.
Wouldn't that be taken into consideration?
I'm sorry?
Wouldn't that selective memory be taken into consideration?
Sure, the nature and quality of a subject's memory is always a factor.
My time has expired. Thank you, sir.